Hi, my name is Lizzie Chan, and I'm a member of the CPR Institute's Young Leaders and Alternative Dispute Resolution Steering Committee. I am delighted to host today's episode of the CPR Y-ADR Corporate Counsel interview series. For those who are joining us for the first time, Y-ADR seeks to educate the next generation of leaders on the full spectrum of dispute prevention and resolution mechanisms, and to provide an insider's view into how CPR's community of corporate counsel, law firm counsel, and other experts in the field are using these mechanisms to manage conflict to enable purpose. As part of this goal, in this interview series, I am speaking to corporate counsel and companies all around the world about their experience with alternative dispute resolution, and to ask them for their advice for young practitioners in our field. Today, we welcome Emilie Bassil, who is Director Legal, Middle East and Africa at SITA in Dubai. Hi, Emilie. We are delighted to welcome you today.
Hey, hello, Lizzie. How are you? Thank you for hosting me.
It's absolutely our pleasure. So my first question for you is, can you tell us a bit about your career background, your current role, and the types of matters that you're involved in?
Yes. After my graduation from St. Joseph University in Beirut, I got my bachelor in Lebanese law, and then I started working in a Lebanese law firm as an intern, and later on I joined the Beirut Bar Association. After 8 years, I got the opportunity to join a regional pharmaceutical company, manufacturers and distributors of medical products. So I joined on a specific project, the one to review all the contracts and just do a little assessment, because I wasn't sure that I want to go in-house. And then I stayed there for 10 years. So I enjoyed a lot this experience, and I moved to in-house lawyer. After this 10 years, I joined another also regional company in Lebanon. And 4 years back, after a very short work as a private practitioner with Dentons, I joined SITA. And now I'm legal director for Middle East and Africa. I'm based in Dubai. And I'm most involved in commercial dispute matters.
I'm so excited to have you here, and so excited to hear how much you enjoy a career as in-house counsel. And I'm sure that many of our audience who are tuning into this interview are interested in how to get a role in-house. But before I get there, there's one thing that I've been asking all of our interviewees, which is about dispute prevention and avoiding conflict. So as I mentioned to you before this call, one of the key focuses of the CPR Institute is to help businesses get back to business. And so one of our initiatives is on dispute prevention and conflict avoidance. And we have an initiative called the Dispute Prevention Pledge, where we ask companies and law firms to committing to take concrete steps to try to avoid a dispute in the first place. So I was wondering, what is your advice on dispute prevention and avoiding conflict?
Yes, first, it's very good and nice to hear about this initiative. My approach personally is to really work towards having a very clear contract where there is no gray area that are later on creating conflicts between the parties. So all the clauses should be really very, very clearly drafted. We shouldn't postpone any potential problem and say, let us now conclude the deal and get it done before the end of the year for our targets, and then we'll deal with any problem later on. No, better to have everything cleared from the start. Second, during the negotiation, it's very important to understand where the other party is coming from and what are their expectations out of that deal, so that we really have a balanced deal, a win-win situation where we can guarantee a long and very good relationship, commercial relationship between the parties. And ultimately, in the dispute resolution clauses, it's always very good to have a certain pre-dispute period where the parties will try to resolve the matter amicably.
I'm so glad to hear you emphasize the importance of the quality of the contract both managing expectations, having a balanced contract, but also having a very well thought out dispute resolution clause. I was wondering, in the context of drafting a dispute resolution clause, what do you see as the advantages and disadvantages of different dispute resolution mechanisms?
You know, when negotiation and dispute resolution clause, it's sometimes very challenging to agree on the other party, especially in, you know, obviously in the international transactions, where we're not all aligned on the institution that we want to use or on the seat of arbitration that we want to choose as well. And we know that it makes a huge difference. And also the applicable law is sometimes challenging for us, you know, because if you choose whatever law that is requested by your counterpart, especially if there are government, client, and later on you need to make sure that the arbitrator will be able to understand this law and produce the award accordingly. Also, one challenging matter is the enforceability of any award. This is something that you cannot really be 100% sure about.
That's a really good point, because, you know, enforcement and the enforceability of arbitral awards is often touted as like the major advantage of international arbitration relative to other forms of dispute resolution. And of course, now we have the Singapore Convention. We're looking at ways to make, you know, mediation settlements also enforceable. So there's a lot happening in this area. You mentioned at the beginning of the interview that you've been in-house counsel for some time now. So I was wondering, what is the most relevant thing that you've learned as in-house counsel?
Well, I learned a lot as in-house counsel. First, I learned that in order to be able to advise the business teams, you have to really understand the industry you're working in. You have to really think and operate in terms of risk assessment. So this is how you would help yourself and help your team to take the appropriate decision. It's all about managing risk after really understanding these risks. We also need to be creative because we need to offer solution to our internal clients to enable business, but at the same time remain compliant with our internal policies and procedures and with the laws.
I'm glad you mentioned the importance of creative solutions, because, you know, as external counsel myself, I think a lot of what is really important for us is to be creative about our legal strategy and really, you know, try to help our clients to get back to business and to maintain the relationships that they want. And I suppose it can often be quite easy to think that, you know, like, you know, if we're arbitration practitioners, it's all about seeing an arbitration from beginning through to the end. But one thing that I've really learned in the course of these interviews is just the importance, for example, of thinking about settlement at various junctures in the arbitration process.
Definitely. And I'm super favorable to settlements because it saves time, it saves money, and it saves also the relationship between the parties.
Absolutely. I was actually speaking to one of our interviewees a few weeks ago, and she was talking about how useful mediation is, because that's really the last point where the business people have the opportunity to be the spokesperson, because once you move into an arbitration or litigation, you then have external counsel speaking on your behalf. And she found that to be a really effective way to convince the business people to engage in the mediation process.
Yes.
I'm definitely going to take this creative solution approach in my own practice. And speaking of creativity, one of the things that I love about your personal story is that you are also a car racer, a race car driver. And I was wondering if you could tell us a little bit about that and what you've learned from that experience.
Yes, actually, I started this because I'm married to a man who is super involved in car racing and whose cousins are the Lebanese rally champs. So when I joined the family, I was more and more, involved into watching the rallies, etc. And then, like maybe 12 years back, a new kind of races were organized, where you have to race in a closed track, and where you can use your own car, if it is obviously a sport car. So my husband was very enthusiastic to try it, and he tried also to push me to do it. At the beginning, I was super afraid, so I didn't. But after the first race, where I was watching him, I felt that no, I'm attracted to this, and I want to try. And this was the start. So I tried, but the first race I was literally shaking. I was shaking completely because I was so afraid. Everyone is watching you, and it's overwhelming. But later on, I used to practice more and more to improve my timing, and I started really, really enjoying the experience. And I actually won the Lebanese championship for many, many years.
Wow, that's amazing.
And also this is when I think about this experience, I think of a sentence that becomes my motto: feel the fear, but do it anyway. So, and this applies to everything in life, honestly. You stretch yourself, yeah.
Yeah, fear the field, but do it anyway. That's my advice that I'm definitely
It's the title of a book, by the way. It's the title of a book, yeah.
Oh, okay. Who's the author?
I'm not sure. I'm sorry. I don't have it in mind now.
No, I'm going to look it up after this interview.
Yeah.
And speaking of great advice, I wanted to ask for your advice for young practitioners who want to move in-house.
They have to expect a different kind of job. It's really a different job. We have both the same educational background, but when it comes to practice, being an in-house lawyer is really different from being a practitioner in a law firm. The approach is different. The interaction with the colleagues is different. So they really have to prepare themselves to be flexible, to listen, really listen, to understand the industry, to understand what's happening around them. And then I think all will fall in place.
I think there's a lot that we can do as external counsel, actually, to understand the client's business better. One thing I can think that young practitioners can do is to build personal relationships with their clients and really just take the time to ask them about their role, how the company is structured, the types of publications that would be useful to read, what kind of horizon scanning about legal risks would be useful to alert the client to. So I'm really glad you raised that.
Yeah.
My final question for you is, if you could do it all over again, what would you tell your younger self?
To be open to all the opportunities, because when I started my career, I never expected myself to end up being an in-house lawyer in a commercial company. I never thought I would be here, and I'm very happy and grateful that I'm here today. So and the first job I got in this pharmaceutical company, they approached me the first year. I said no, and they approached me the second year. Then I said yes, and gladful. I'm glad I said yes. So we have to be very open to all the opportunities, and not to settle for mediocrity, I would say. Wherever we feel that we reached our limits in terms of personal development, if we feel that we're really in our comfort zone, we have to stretch ourselves and just leave our comfort zone and look for something more challenging.
I love your advice to be open to all opportunities. And, all of us living through the COVID-19 pandemic has probably been presented with so many challenges and so many opportunities. I can think one for me is, I wouldn't have imagined being a YouTube interview host and having the opportunity to connect with you.
Yes, same for me, Lizzie, honestly.
So it remains for me to thank you for your time, Emilie, and for sharing your advice and your very exciting life story. And I thank our audience for tuning in.
Thank you, Lizzie. I thank you for this very nice and smooth interview. Thank you.
Thank you again. Bye.
Bye.